In this video, I'm going to be answering your latest questions on the Lucy Letby case, so without further ado, let's get into it. First question is, are any of the other side willing to debate? So there's a few things that I can say about this. The first thing is that I will never participate in a debate. There are several reasons for this. The first one is that I'm not really an expert, I've never claimed to be an expert, and I'm not the ideal person to participate in a debate, and I recognise that. Obviously, I know a lot about the case and I could do a reasonably good job, but this should be debated by people who are experts if there is a debate. The second reason I wouldn't participate is that I don't really think debates solve anything typically. What happens is two people go in with an entrenched viewpoint, or two sides going with an entrenched viewpoint, and then everyone retains the same view at the end of it. I'm not sure people watch debates and then change their mind. It's usually people that have a polemical view on something, and then at the end of it, they still think they still have a polemical view, and then the people that had the polemical view beforehand, who watched the debate, think that their side won whatever is said. So I really don't think debates serve any purpose in that sense. And then another thing I will say is that I can't see any particular reason why I should give a platform to someone else. I mean, I worked incredibly hard over the last 2 years to research my book and write my book, and I've built this YouTube channel I've got well over 4,000 subscribers now. I'm very grateful to have that, but that was a lot of hard work to do that, and I had to do high quality work and do it consistently and make this the primary focus of my entire life. And with the greatest of respect, there is no one on the other side who has done anything like that. They've contributed very little, really. They haven't produced anything of substance in terms of writing. None of them have a platform that's anything like this. And really, I would describe as witter on endlessly on social media to an audience of very, very few people. So why on earth should I give them a platform? Why should I give anyone else a platform? And let me compare this. So I'm sure people are aware of the Lucy Letby Reddit. If you try to write anything on there from an innocence or pro miscarriage of justice perspective, they delete it and they ban you. So I'd be perfectly willing to discuss this matter if I saw maturity from the quote-unquote other side, as you've described it here. But frankly, I'm not going to share my platform with someone who's contributed nothing, who's achieved nothing, who's produced nothing. Why should I? I have a series of questions concerning the sewage issues. Where did the overhead sewage pipe run that would leak that Caroline Oakley mentioned where Baby D's cot was? So it's very difficult to find out the precise details of this. I have looked into this and I have tried to ascertain exactly where it was, but it's very difficult to do this. There is obviously mention of this in the court case, and it's still not entirely clear, even if you read through what is available of the court proceedings related to the sewage. So I couldn't say with 100% certainty, although this is something that I'm aware of, but it's very difficult for me to give a precise location of this, especially as this neonatal unit will be demolished pretty soon, I think. In terms of whether the pipe here is made out of cast iron or lead, everything that I've read indicates that it was cast iron. I don't know if there was lead piping on the unit, but it's mentioned in court as being cast iron, and references that I've seen to have been cast iron, so I would assume that it's cast iron. I think the third question is just too difficult to answer. When was this pipe rerouted to follow the wall instead of diagonally? So I just could not find out any information on this. It's incredibly difficult to search for. And maybe these are questions that I could put to Michelle at some point. It's really asking for some very specific information on something. And I delayed answering this question for quite some time, trying to find out the answer, but I couldn't find out all of the answers. But I know there was an overhead pipe. I know there was some rerouting that occurred. And I do believe it was cast iron. Based on what I've read, that would seem to be accurate. Why did the judge allow his opinions after they were changed, as Evans said, by other people? These people have given evidence in a murder trial, and nobody in prosecution or defence knows these people or what qualifications they have. I'd have hoped the defence would have asked Evans to provide names and qualifications of these mysterious new prosecution witnesses, but Judge Goss should have halted this immediately after hearing evidence from unknown persons that were just introduced into his court. So I think this is a question about Dr. Evans changing his opinion on child C. So I think what he was saying was that he changed his mind based on comments that were made in court by people who worked in the hospital and perhaps some of the other expert witnesses. This is completely without foundation. It was just a stupid claim. Obviously, he's written a letter that I've exposed on this channel in which he said something completely different. We know for a fact he didn't say that in court. So, I mean, Dr. Evans, in my estimation, is a person that's willing to say anything. In terms of the role of the judge here, I don't know what should happen and I don't know what shouldn't happen, but it's easy for us to see that this, in any kind of moral or ethical sense or in any kind of credibility sense, should never have been allowed to happen. Whether it can be allowed to happen legally, I don't know. If you consider this under normal circumstances, it'd be like saying a burglary took place on the 12th of June. Oh no, actually it was the 13th of June, but it's still the defendant that committed the burglary. I mean, surely that wouldn't happen. It seems to me that Judge Goss just doesn't understand the case. You know, he's essentially old and complacent and has just allowed this guy to do whatever he wants. Obviously, he should have been... The bottom line is he should have been thrown out the case. As soon as Lord Justice Jackson wrote to Goss and said this guy's evidence was worthless, he made no effort to give a balanced opinion. He should be gone immediately. That's obvious. So I'm critical of Judge Goss for failing to do that. But if he's not going to throw him out the court case, you might as well just let him change his evidence around. As for the fact that we're going to assess later in this Q&A session that Dr. Evans changed his evidence after and changed his opinion, even fundamental opinion, after the court case was finished, this is just surreal and extraordinary. And I'm not sure what else to say about that, but we'll discuss that later on. What was the reasoning behind Cheshire Police's decision to take Evans on board as their expert when that man was retired and not even registered anymore as a medical practitioner? And what is or was his expertise in the first place that they thought they had the best possible expert witness in what even the police must have thought is an enormously complicated case which requires very careful and thorough investigation and expertise if there was a case to begin with? What we now know is that there wasn't. I think it's called due diligence in the English language that was and still is lacking here on behalf of the police investigation team and the prosecution team. So I would certainly agree with you that there was a lack of due diligence from the police. In answer to your questions, even Cheshire Police may have realised that Dr. Evans was not the best possible expert witness, but what he was the best possible expert witness that was available to them. So they were probably, and in fact we know from their communications, that they were pleased just to have an expert, and they didn't see any problem with basing everything on Dr. Evans. Of course, we now know they have allowed Dr. Evans to say to them, you don't need to get anyone else in, you don't need to have a multidisciplinary review, just base everything on my work. So I think the most generous spin you can possibly put on it is that it's gloriously naive from Cheshire Police. Obviously, they should do their due diligence. Obviously, you're right to point out this guy's not even registered, been retired for a long time. But I think from a police perspective, they're probably just thinking, he's on the NCA list, he's on the National Crime Agency list, we're entitled to use him an expert, we will use him an expert. And I think it's quite likely they just got carried away and they got giddy about the fact that this was the biggest case they've ever dealt with and the most important thing they would do in their careers. And they haven't done their due diligence, and the investigation has been shambolic, frankly. I don't have a good explanation for why they did what they did other than that. And I think even if you were to ask them, what was your reasoning, they'd have to come out with some rather feeble PR explanation. They can't give a good explanation because there isn't one. So then there's the follow-up question of surely you aren't allowed to change your opinion about the evidence once it has been heard in court. Well, actually, you are allowed to do that. It's perfectly permissible for you to change your opinion in court. What is obviously strange in the case of Child C is that we see the date being changed from the one they went into court intending to use to a completely different date, as far as we can see, because Lucy isn't on duty on the 12th of June. So that obviously should be a massive red flag, but it is permissible if the judge allows it. Now, the judge knows legally you're allowed to do this, and indeed, there can be legitimate reasons to do this. So Dr. Evans is aware of that. In some respects, he's quite shrewd in what he does and says. In some respects, he definitely is not. And he's changed his opinion. He's allowed to do that. It's perfectly admissible under the rules of the court. Obviously, from our perspective, we look at it and think, well, the guy's a shyster. How can this be allowed? But it simply is allowed. Surely if there is proved to be incorrect evidence presented by the prosecution, would that not invalidate the whole proceeding? Well, I've done a video on this, and it's fairly extraordinary what has occurred with regard to this, and particularly given the post-trial statements of Dr. Evans. You know, in my estimation, it does invalidate the whole thing, undoubtedly. However, this will be something that will be brought up at the Court of Appeal, and it will be for the Court of Appeal to decide on this. Whether it legally invalidates something or not, I don't know. It obviously seriously damages the credibility of Dr. Evans and the prosecution of Child C at the very least. Has Evans acted as an expert witness in any other cases since the trial? No. So he won't. There's absolutely no chance anyone would take him now, and he is quite old, and he announced his retirement. But frankly, why he wasn't retired before this, I have no idea. He should never have been allowed anywhere near this court case. Why aren't Evans and Jayaram in for questioning yet, and the other conspirators in the email exonerating Nurse Lucy on the bedside incident where she, and it wasn't Lucy Letby, was remembered falsely 18 months later as not having caused a desaturation emergency? So there's the official line on this, and there is actual reality. So the official line on this will be, the police haven't said anything, so they're probably never going to make an official statement on this matter. I'm not sure if they will or not, but it seems very unlikely that they will, in my opinion. However, if they do make an official statement, if they were actually goaded into saying something, they would say something like, we're still investigating the circumstances and we haven't decided anything yet. I simply believe that they will never do this because, I mean, in the case of Dr. Evans, it's not really their place to do so because he hasn't been reported for any reason. So there's no reason for them to do that. In the case of Dr. Jayaram being referred by Sir David Davis for perjury allegations, if they were to seriously question and arrest Jayaram in relation to this, their entire narrative would have collapsed. And it's very clear that the Cheshire Police, and they're not alone in this, are a very self-serving organisation. So I don't think for 1 second we'll ever see Jayaram called in for questioning. And the executives will never be charged, the executives that have been called in, because there's no evidence, and based on what we know now, it would be utterly farcical. So I just don't think either of those things will progress, because there's no legitimate reason to charge the executives, and that there's no way that they can seriously investigate Jayaram, because their whole narrative that they're desperately clinging to would just collapse immediately. So next question is, Baby C was said to be at high risk of collapse. Is this a special kind of collapse that is always survivable? So, I mean, all I can really say is that the whole proceedings related to Child C were an absolute dog's dinner. No offence to dogs. You know, I love dogs, as you know. It just beggars belief that this was put in a courtroom by adults and people were paid a lot of money to do it, and it was taken seriously, and someone went to prison because of it. I mean, Dr. Evans and his reports on this infant are laughable, utterly laughable, and that's all I can really say about it. The post-mortem causes of death in Thirlwell included widespread cardiac muscle infarction, so likely the conducting system was affected too. This causes arrhythmias and sudden death. Respiratory distress syndrome due to surfactant deficiency and intrauterine vascular underperfusion, presumably placental underperfusion, likely an intrauterine growth restriction. Was this all discounted in favour of the inflicted harm hand waiver on his own, or who in the team helped him, he said, reach this contrary conclusion? And where, more importantly, is the evidence for a dilated stomach bowel on the 13th? Baby's X-ray gas patterns change up and down very quickly and very frequently. So, let's answer these questions in order. Was this all discounted in favour of the inflicted harm hand waiver on his own? Yes, it was. In terms of whether anyone on the team helped him reach a contrary conclusion, absolutely not. So we know for a fact now, again, that basically Dr. Evans has just presented his conclusions to the team, as you put it, very accurately, I think, and they've just rubber stamped them. In some cases, they've not looked at the case notes. There's not been any significant contribution to these theories from other experts. Also, we know for a fact Dr. Evans ran the whole process. We know for a fact that Dr. Evans has hand-waved the idea of a multidisciplinary panel. We know that Dr. Evans, the sole opinion of Dr. Evans had been sought at the time that Lucy Letby was first arrested. We also know Dr. Evans changed at least 25 of his reports, or submitted 25 new reports, after he definitely knew the name of Lucy Letby and knew that Lucy Letby had been arrested. So absolutely, undeniably, it's Dr. Evans on his own. In terms of the evidence, as far as I'm concerned, there just isn't any evidence for this at all. It's just absolute crap, frankly. Why was this post-mortem determined list of serious diseases not mentioned throughout that transcript, and only concentrating on pneumonia, serious enough as it was superimposed on that list above? Why was this post-mortem determined list of serious diseases not mentioned throughout the transcript, and only concentrating on pneumonia, serious enough as it was superimposed on that list above? Well, essentially the reason for this is that Dr. Evans has diminished anything other than the involvement of Lucy Letby in malfeasance is basically the reason. I should just briefly mention that he ruled out pneumonia as being significant, which he just simply cannot do. I mean, I've had experts tell me this. So even his ruling out of pneumonia wasn't legitimate. The other things are just ruled out because they're not convenient to the opinion that he wished to express in court. Chris, I don't know if adding this data to ChatGPT might then conclude that Dr. Marnerides was the source of Evans modifying the splinting of the diaphragm significance dating. So no, he wasn't. He definitely wasn't. To be honest, the explanation that was given in court by Dr. Evans is spurious. So, I mean, really investigating it any further is pointless because there's no basis or foundation for it in the first place. So, that's all I can say about that. With every new analytical video you present, Chris, it becomes ever more apparent just how sickeningly monstrous these trials were. Chilling, in fact. Just as an aside, I'm wondering if you've ever considered the principles as set out in the Bradford Hill criteria, which you might know is applied to epidemiological evidence and is not therefore an exact equivalence. And yet it might be useful in illuminating how coincidence has played a significant role in shaping the prosecution's confident claims. So I had never encountered the Bradford Hill criteria before, so we're just going to have a quick look at that and consider these comments from Brian. So I can say in all honesty that I don't know the first thing about the Bradford Hill criteria. So here on Wikipedia we learn that the Bradford Hill criteria, otherwise known as Hill's criteria for causation, are a group of 9 principles that can be useful in evaluating epidemiologic evidence of a causal relationship between a presumed cause and an observed effect, and have been widely used in public health research. They were proposed in 1965 by the English epidemiologist Sir Austin Bradford Hill, although Hill did not use the term criteria himself and instead described 9 viewpoints from all of which we should study association before we cry causation. So it's defined in 1965 as these 9 contributing factors, these 9 principles to consider when evaluating epidemiologic evidence of a causal relationship between an exposure and outcome. The list of principles is as follows: strength, consistency, specificity, temporality, biological gradient, plausibility, coherence, experiment, and analogy. Some authors consider also reversibility. So I am completely unqualified to answer your question. So all I could reasonably do was ask an LLM, which I always use ChatGPT. So I simply asked, I'm wondering if, so I asked this question, I typed in what this person said and said, are these fair comments and could they have played a significant role in assessing claims made in the conviction of Lucy Letby? Short answer, yes, your point is fair. The Bradford Hill viewpoints are a useful structured way to interrogate whether an observed pattern is more likely to be causal or the product of chance/confounding. But they were developed for population-level epidemiology, not as a plug-in test for individual criminal cases. Applying them carefully would have helped critics and defence experts to spotlight where the prosecution's pattern-based case about Lucy Letby relied on coincidence, weak mechanistic links, or statistical assumptions that deserve close scrutiny. And then there's a lot of discussion about this. And this talking about the specific statistical danger of clustering, which we know about. And they're talking about various things to do with strength and consistency, specificity, temporality, plausibility and coherence, and so on. Bottom line practical, could Bradford Hill have helped assess the claims? Yes. As a structured critical tool, it would have been helpful to force experts and the court to state clearly where the empirical support was strong, e.g. clear temporality, reproducible biomarkers, and where it was weak, e.g. absence of independent epidemiological association, lack of plausible mechanism. But Bradford Hill would not substitute for the legal standard. It can help show that observed clustering is plausibly due to chance/confounding, and then in brackets, weakening inference of deliberate acts, or conversely, corroborate causation if several viewpoints strongly point that way. In short, it's a helpful forensic epidemiology checklist, not a legal silver bullet. So then ChatGPT offers to apply each Bradford Hill viewpoint to the prosecution's publicly reported claims one by one, pointing to the specific trial evidence and published critiques, or produce a short plain English briefing. So it might be very interesting to look at that one day. I mean, I'm kind of loath to make a video that's entirely based on a learning language model applying something to available information. It may be interesting, but I suppose the basic answer to your question is that you make a legitimate observation and it could have legitimacy to have used these Bradford Hill principles that I'd never heard of previously. I'm perfectly willing to confess. So the next question is, do we know if little baby K was receiving surfactant? I've never heard or I've missed it. Does anyone know, please? So there's a simple answer to this question. Yes, child K was definitely receiving surfactant or had received surfactant while at the Countess of Chester. So not much else that I can add to that. Regarding child K, what defence did Myers put up? Once again, I believe he didn't call a medical expert witness. I can't find confirmation of whether Evans or Bohin were called. So I don't think Evans and Bohin are part of this retrial, as far as I recall. But in terms of Myers' defence, I know someone that attended every day of the retrial, and that person told me that Myers absolutely annihilated Jayaram during the retrial. However, I just don't think there is any defence team. I don't think O.J. Simpson's defence team could have got Lucy off on this charge, because you have to remember the climate that was present at that time. It seems so long ago now. We have to remember this was 18 months ago, and there hadn't been the Guardian article, the initial Guardian article by Felicity Lawrence at that time. There hadn't been the initial Daily Telegraph article by Sarah Napton. And it was a completely different climate, albeit the New Yorker article had come out. I didn't think Lucy had the slightest chance in that retrial because everyone in the country had heard that she was a murderer, and that message had been rammed home, and even the New Yorker article had been banned in this country. So I must say that I didn't even follow the retrial because it was too depressing and I knew she would lose. And I think emblematic of that is the fact the jury only were out of the court for a couple of hours because they just believed, well, this woman's a murderer, she's obviously murdered this infant or attempted to murder this infant as well. I don't think there's anything Myers can do. I think it's as close as you can get to a trial by media in this country. As far as I'm concerned, it was a trial by media. It was just a completely unacceptable situation. It wasn't a fair trial. How could it possibly be a fair trial? And I don't think there was anything Myers could do. He didn't call a medical expert witness, but then there wasn't much medical evidence. Even the prosecution said it all comes down to whether or not you believe Dr. Jayaram, after he just said over and over again, Lucy Letby did this, Lucy Letby did that, then Lucy Letby did this. So what chance did they have? I would say no chance whatsoever. Chris, what I'm attempting to find out is when the defence exactly became aware of the error in door swipe data evidence that was announced during the trial, but which in the media was said to be discovered in February 2024. Was it only at the trial, or were they made aware at the time of discovery, or later but before the trial? Further, how was the error discovered? If discovered on February the 24th, why was it not made public before then? Were the appeal court judges in April 2024 for the first trial aware of the discovery of the error? While acknowledging the error at the time of the second trial, it seems on the face of it that the defence made no attempt to incorporate the change in circumstances in the defence of Lucy. So there's a lot of questions there, some of which are very difficult to answer. In terms of whether they were made aware at the time of discovery or later but before the trial, it's very difficult to know because the defence hasn't given a lot of indication about anything. In terms of how the error was discovered, I think this may have been a freedom of information thing. I'm not entirely sure, but I believe that it could have been derived from freedom of information inquiries. If it was discovered on the 24th of February, the reason is probably because this is when these freedom of information requests came to light. The appeal court judges in April 2024 for the first trial should have been aware of the discovery of the error. However, if it didn't form part of this submission to the appeal court, which it doesn't seem to have done, then there's no way the appeal court can reference that, and there's no reason for them to do so. In a way, it's a good thing it wasn't included because now it can be included in future appeals that actually have more substance than the initial appeal. While acknowledging the error at the time of the second trial, it seems on the face of it the defence made no attempt to incorporate the charges in circumstance. I think that's a fair comment. It does appear that they didn't do that. As far as I'm aware, they indeed didn't do that. So, yes, that's a fair comment. It is a confusing issue, but I think this all came to light because of freedom of information. And perhaps it was too late for the appeal from Ben Myers to utilise this information. But to be honest, that's a good thing because that appeal was never going to succeed. And now there's a far, far stronger appeal, of course. I'm interested to know some statistics, since statistics play such a great part in this trial. How many deaths occurred over the years in the unit before Lucy arrived, these being presumably by natural causes? How many natural deaths in the years Lucy was there? Were there any significant changes to staffing levels, personnel, working practices during all this time? So it's very difficult to get all of this precise information because hospitals do not release these figures. The only reason we know these figures for the Countess of Chester in the trial period is because there was a trial and there was a police investigation. It's similarly very difficult to find out figures for after this date or indeed in relation to any other hospital in the country. So it's difficult to answer your questions. However, it is known that I think with regard to staffing levels, personnel, working practices, they were having a particularly difficult period in 2015-2016, but all the key decisions to downgrade staffing had already been made. What was particularly bad at that time was the acuity and difficulty of the infants that they were dealing with, which when combined with the staffing levels, personnel, etc., caused problems. How is it that Judge Goss was appointed to both trials? Is it usual to have the same judge in related trials? So I think this would be normal practice. There's an obvious reason for having the same judge presiding over both, given that he was the original court judge. I don't think it's mandatory, because Judge Goss could have died, as an example, and then obviously they can't say, well, the original judge has died, so we're not going to have a retrial. So it's not, I think it would be usual if the judge is available. It's probably dependent on multifarious circumstances. I think it would, you could probably describe it as usual, but at the same time, it's not so usual as to be the only possible scenario, because there could be any number of reasons why the judge isn't available, in which case they'd have to find a different judge. But I think for a trial of this complexity, although some people have been critical of Judge Goss, and I am critical of some of the things that he did, he would be a logical choice given that he presided over the original trial. It has been mentioned to me that the Hillsborough Law could apply to people like Paul Hughes in this case. Well, that's definitely possible, but it remains to be seen because it got to be backdated and there are question marks as to how that would occur. So I wouldn't take for granted that the Hillsborough Law will apply. It would depend on certain legal verdicts as to whether it did or not. I noticed that recently there's been more news on Hillsborough and the police have got off scot-free yet again, and the families are saying we've got no hope, we don't have any faith we'll ever see justice in this case, which is understandable because obviously it's now 36 years since the Hillsborough disaster took place. I mean, I remember it very clearly. That there were a lot of horrible things that happened in football at that time, with the Valley Parade fire and the Heysel Stadium disaster. It was pretty awful. And obviously Hillsborough is a travesty of justice in my opinion, but we can't say with any certainty that it will be applied to Paul Hughes, Cheshire Police, or the Lucy Letby case, but it's possible. If there isn't a retrial, does that mean there's no hope of Lucy getting any compensation? So I would suggest to you that if Lucy, I will say when Lucy is exonerated, this will become so high profile, there will be enormous pressure on the system to compensate her adequately for what has occurred. I think whether or not there's a retrial is going to be irrelevant. What usually occurs is that if someone cannot be proven to be truly innocent in the system's definition of that term, then they won't necessarily be compensated. But in this case, that would be such a travesty, it'll be so high profile, there'll be so much fallout. I can't believe that Lucy's not going to receive compensation, although, we'll have to campaign for that, and I will try to be involved in that. We shouldn't take it for granted, but it's the public outcry will be enormous, and I do think Lucy will be compensated. A retrial doesn't rule out compensation, because in a retrial there could be evidence that overwhelmingly points to innocence. One would expect under those circumstances that the Court of Appeal would quash the verdict, but you never know what the Court of Appeal is going to do next. So I don't think the existence of a retrial automatically rules out compensation, but then we must remember that prisoners that are exonerated are not compensated in very high proportions. It has to be overwhelming evidence of innocence, and even then they have to fight for compensation. But I do think Lucy will receive compensation for the reasons mentioned. Do we know if the jury were told that Lucy Letby was originally charged with the murder of baby Kay, and that the charge was withdrawn and changed to attempted murder? This all seems to have happened in great secrecy just before the start of the main trial. I presume this happened because the prosecution belatedly realised that baby Kay died at a different hospital 3 days later, but I would love to know more details. This is a very interesting question, a very interesting point. So it certainly is bizarre what occurred with regard to child K. That's the first thing that I will say. And I don't know if it's reasonable to describe it as great secrecy, but all of these things are quite secret in their way, because what goes on in these meetings is never recorded. So it's certainly private, and it would be reasonable to describe it as secret. So I don't think we know all of the answers to these questions. We can only presume that the prosecution must have realised that it's going to look ridiculous if we try to have Lucy charged for murder for this case where the infant dies in another hospital 3 days later. Given how shoddy the prosecution is, and given how shoddy the investigation is, and given how shoddy Dr. Evans is, it's possible they didn't realise that this infant died 3 days later, but I think that's unbelievably unlikely. I think it's highly, highly likely that they knew, and as to why they were trying to charge Lucy with murder, one can only imagine, but anything is possible in this most surreal of cases. In terms of whether the jury were told that Lucy Letby was originally charged with the murder of Charles Kane, that the charge was withdrawn and changed to attempted murder, this wouldn't be usual, because the usual processes in court are to discuss the charges that the defendant is appearing to indeed be defended against. All I can say with regard to this is that I've looked at the court reporting and there's no evidence that this was ever mentioned. It does seem like the kind of thing that could be mentioned in court, but whether it would be, what Ben Myers knew at the time, I don't know. But Nick Johnson indicates that it's an attempted murder during the proceedings, and I see no evidence that this was contradicted in any way. But I could be wrong. It's very difficult to know, seeing as it's made as difficult as possible to find out exactly what happened in court, but it doesn't appear that this was ever mentioned to the jury. Another great piece of work, Chris. I have a question which may be worth pursuing. Planning ahead, assuming there is a referral from the CCRC to the Court of Appeal, what happens if the Court of Appeal finds against Lucy? Can she turn to the Supreme Court? If so, in what circumstances? It seems to me that the Court of Appeal will be even more cautious of dismissal if it knows the Supreme Court is mapped out as Lucy's next step. AI hasn't helped me here, one for the lawyers. So this is a tricky question to answer, but I'll try to go through this point by point. So if the Court of Appeal finds against Lucy, that would obviously be something that most people that watch this channel, the vast majority, would not want to happen, but it's something that we need to consider because it could occur. So there are numerous options available to the defence under those circumstances. One of the options would be to release the reports into the public domain. That would be kind of a nuclear option. Whether or not Mark would do that, what recourse he would... It's very difficult for me to say what would occur strategically, but that is possible. In terms of whether Lucy can turn to the Supreme Court, it's certainly possible to make an application, and as far as I understand it, the Court of Appeal presides over this, which is pretty extraordinary. One of the things about the Supreme Court is they typically, I think, overrule cases based on procedural issues, and it doesn't seem that there are procedural issues in Lucy's case. So whether she could go to the Supreme Court or not, I don't know. Let's just hope this doesn't happen, because I don't really have good answers regarding what would occur exactly, and I don't think anyone knows for sure. I'm sure this is something that Mark MacDonald has considered, and I'm sure that he will have a strategy in place, but it is very, very difficult if the Court of Appeal finds against her. By that time, though, public opinion could be very much on the side of Lucy. I mean, I believe that it is now, but obviously my reason for writing a book, and hopefully there's going to be more related stuff in the future, is to help people understand, people that don't have the time to follow this case, to help those people understand, and to help there be a stronger public opinion that indicates that this is a miscarriage of justice. Now, under those circumstances, if the Court of Appeal finds against her, this could be very problematical for the criminal justice system, and they'll be aware of public pressure, which is why public pressure is so important in this case. I wonder if Lucy's counsellor was unable to give testimony due to patient confidentiality. Also, would Lucy's defence have been hampered, unable to hire more expert witnesses because of financial constraints? Obviously, this doesn't excuse their failure to respond to those experts who contacted them. So, I don't think patient confidentiality would have been an issue with regard to Lucy's counsellors. This doesn't really apply in a court case scenario. I think simply, for whatever reason, when they've been having their meetings, Lucy's going to be in a traumatised state. She perhaps just didn't bring to mind the fact that this was important. I know for a fact that the comments about Kathryn de Beger that have been reported in The Guardian are correct, and that it was suggested, if not instructed, that Lucy engaged in this exercise. I know for a fact that's true. As to why Ben Myers was unable to identify this and unable to identify the counsellor and unable to call her as a witness, is impossible to say. There could be any number of reasons, we just don't know. It seems to me that if he knew about Kathryn de Beger, he would have tried to at least call her and she would have had to give testimony, but obviously he didn't go down this route. I have no idea what Ben Myers was doing or why he chose to do what he did. In terms of whether financial constraints hamper Lucy's defence, this is one of many factors that hamper the defence in acquiring experts. There are several others, including reputational risk, the amount of time that has to be invested without potential remuneration, and there are many other factors. So it is difficult for the defence, and I do have some sympathy, and certainly financial constraints can be a significant factor. Saline bags are double wrapped and only open just before use. If the outer wrapping is removed, the saline will be rejected. Is this the same for feeding solutions? So Michelle gave a lengthy answer to this question in my interview with her, but I will just show you briefly what ChatGPT has to say about this topic. So I didn't know the answer to this question, but simply it's not the same because feeding solutions are handled differently. Saline is a sterile product. The inner bag is only considered sterile while the outer wrap is intact. Removing the outer wrap early breaks sterility and it must be discarded. So I'm not sure why that's different. Enteral feeding solutions are not sterile in use in the same way IV fluids are. The outer wrap is for protection, not sterility. Removing the outer packaging does not automatically mean the feed must be rejected, provided the inner container is intact, the solution is in date, has not been opened or contaminated. So I think here ChatGPT has essentially not understood the question. It is the same. It is the same. If anything, saline would be rejected more easily because it's a sterile product. So the answer to your question essentially is yes, as far as I can see it. Given the massive turnaround in police attitude on the 15th of May 2017, could it be that 3 doctors insisted there had been murders and suggested there could be serious consequences for the individual police officers concerned if their concerns were not acted upon? Well, based on the minutes of the meeting, no. This was not used as a line of argument. It's certainly possible, but based on what we've seen, no. And I think you've got to be pretty bold to go in there and start saying, oh, if you don't investigate this, there could be serious consequences for you. I don't think I'd be brave enough to say that to the police, personally. But yeah, there's no evidence that ever happened. Is it possible that the CPS will seek to reduce their embarrassment by blaming one of their staff and forcing a resignation? This is always a possibility because a sacrificial lamb always works well for any organisation. I think it's probably unlikely because I think according to their own regulations and guidance, the CPS have done nothing wrong. The problem is that systemically and in terms of the organisation as a whole, the CPS is not fit for purpose. So they could do that, but I don't think it's very likely. The silence from the CPS over the arrested managers and Liverpool Women's Hospital investigations may indicate the CPS realise the fragility of the whole case, or do you think they are working with the CCRC on how to proceed? So it's impossible for me to answer this question. The first thing is it's important to note that the arrested managers haven't been referred to the Crown Prosecution Service, and I don't think they ever will be, because there's absolutely no basis to do this. In terms of the Liverpool Women's Hospital investigations, it would enormously surprise me if Lucy was charged, because it's such a complete and utter joke, and that court case would be farcical. I can't say with absolute confidence that Lucy won't be charged. We don't know what will happen. I can't comment on whether they're working with the CCRC. That's a distinct possibility that there've been discussions, obviously. But it would amaze me if Lucy was charged, because these are trumped up charges, and it will be a complete joke. And there'll be the court case. We can never predict the verdict, but the actual process will be an annihilation, given the calibre of experts that are now available to Lucy's defence, and given the weak, feeble nature of these charges. So it's likely it will just disappear. The CPS can just be very quiet about it and just say, oh, we're still considering it, They do dilly-dally and take a long time over cases, so we may never hear anything about this, ever. One question though, when an expert witness like Evans is found to be problematic, why wasn't he placed on a barred list, like when police officers are discredited and sacked? So I don't have a good answer to that question. I don't know how the NCA list works exactly. It does seem to me, as you've rightly stated, that Dr. Evans should be gone immediately once he's been described as worthless, and this wasn't the first verdict where he'd been criticised. However, there could be a lack of joined up processes. That's often the case, and it could be that a judicial verdict is not reported to the National Crime Agency, and therefore Evans remains on the list, and so therefore we have the disastrous circumstances where he's involved in this case. That is what I would probably attribute it to. I've seen many, many examples of a lack of joined up procedures, and this is probably another one in my opinion. Can you assist? I seem to recall, I believe it was Michelle speaking of GOSH in the early 2000s. It was said at that time it was a level 3 unit. There was then a general reorganisation which turned GOSH into a level 2. I believe it was said at that time that the unit released its practitioner nurses as well as 7 registered nurses. I cannot find the reference for this now. I am hoping that I am not dreaming. Also was Dr. Brewery on the unit at that time. So it is true, Michelle did say that there was a big reorganisation. Michelle's told me a lot of things. She features I'm sure it's not a huge surprise that she features prominently in my book, and there's stuff in there about all of this. There was a lot of reorganisation. There was a lot of people getting sacked, or being made redundant, I should say. And a lot of things occurred at that time. So there were a lot. I think to call it general reorganisation is perhaps not quite accurate. There was just an ongoing downgrading of everything on the unit, with nurses being made redundant. And it ultimately resulted in the perfect storm that we saw in 2015 to 2016. Dr. Brewery was not on the unit at that time. Michelle answered a question recently regarding when Dr. Brewery joined the Countess of Chester, and it was well after this period. So he wasn't on the unit at the time this was occurring. You are a chess player. One of the rules of the game is to attack your opponent where he is weakest. Wouldn't Baby K be the obvious place to start, since it is such low-hanging fruit, and the conviction being overturned would discredit one of Lucy's main accusers in a major way? So I think I need to be a little bit careful with what I say about this. But when Mark MacDonald appeared in Manchester, during his presentation, no one unless you were at the event, you won't know this. But I asked the first question of Mark, and I asked a very similar question to this. That question's been edited out of presentation since, as far as I can see. I haven't watched it all the way through myself because I was there, so I haven't watched the talks back. Or I haven't, I'd like to, but I'm sure you can appreciate my time is not in huge supply, my spare time. So I need to spend my spare time on productive activities. So it's either pursuing new avenues, doing productive, constructive work for myself, or having a rest. and I don't get many rests. So I haven't watched them back, but this question was edited out. I can see the logic in what you're saying, and I raised certain cases and said, would you target these cases? And Mark did give an answer to that question. I don't know if I can reveal the answer, and I probably shouldn't. But what you're saying is entirely logical, but it's actually not, from a legal perspective, the right way to go. Let's just say that. The police's interest being piqued at the meeting with Jayaram, Brewery and Holt. I personally think it would be incredible that the reason was not stated in some form of minute. The police, you would think, would have to write as justification to future-proof inquiries and the serious spending involved. There has to be a formal complaint somewhere. Has anyone from Cheshire requested this under freedom of information? So it's very difficult for me to know whether or not there's been a freedom of information request. What I can say is that we know a lot about these police meetings now. And I think that, at the risk of blowing my own trumpet, I think I have uncovered quite a bit myself that wasn't broadly known prior to that. And there's going to be more on that in my book as well. So I think in terms of police minutes, there could be something that we haven't seen, and it's possible to make a freedom of information request. What I would say is that the police are pretty much a law unto themselves and are unlikely to release anything that would be bad for them. The other thing I'll say is that we don't know what is available in terms of other minutes. We've seen a lot of stuff from the police and a lot of documents, so there could be other documents, but it may be that they don't actually exist. There are documents that are in the Thirlwell inquiry that basically give the reasoning, and then we saw there's Nigel Wenham speaks at the Thirlwell inquiry about the kind of feelings towards the paediatricians at that time. It's all deeply incompetent and unprofessional in my opinion, but yeah, it's impossible for me to say whether anyone's requested this under FOI, but I think an attempt to do so is likely to be unsuccessful because the police just don't release things, basically. It's ironic if it was, as you surmised, Jayaram's belated memory for child K, surely an entry for whistleblower of the decade, as it took him a good slice of a decade to remember it happened, despite it being something he will remember to the grave, as that was the retrial case. They couldn't convince the first jury even. Was the event remembered in any different way or detail between the two trials, I wonder? If, as it looks, he proves to be a fantasist responsible for false imprisonment, doesn't he deserve some serious sanctioning? So it would be very difficult to directly compare the two, again, not least because it's made as difficult as possible to have the court transcripts. We can compare the proceedings, and maybe that would be an interesting thing to do at some point. It wouldn't surprise me if his memory was slightly different over the two trials. That wouldn't be surprising, would it? We'd have to compare the two. What I will say is we've got the entire retrial now available, and obviously there's a lot of details related to the initial trial, but it was dealt with in much more detail for the retrial, so it'll be interesting to have a look at that at some point. What I can say is that I've got so many things to look at. There's so many aspects of this that I've either barely scratched the surface or not even looked at all. I mean, there's many, many more years of content. I don't think I'll ever complete the job because I think Lucy will be exonerated before I do. But I'll never run out of things to explore and things to discuss. So it's possible that I'll look at the retrial in some considerable depth at some point in the future. I have now finished the video. Please forgive me the liberty of a third comment. Since it was myself that made the collusion comment, I feel I misspoke a little. I wasn't trying to outright allege a criminal conspiracy so much as wishing to ask the question of whether there is any regulation regarding keeping pieces of evidence separate. I think this could be difficult in practice, but I feel that particularly eyewitness testimony shouldn't be coloured by confirmation bias. For instance, when Jayaram claims to have seen Lucy at a certain time, has he seen the door swipe data? I don't know whether he had, or if it's illegal for him to have seen it, but if there's a possibility that he had, there's surely a big question around the independence of his testimony. So again, it's impossible for me to know this. What I can say is that it's very clear that there are enormous question marks around the certainly reliability of Dr. Jayaram's testimony. Whether or not he's seen the door swipe data and whether or not he knows all the problems, etc., etc., I feel that he must be familiar with it because in the retrial they changed the times quite explicitly. So he must be aware the prosecution case is different. He may not be, because he's not privy to the prosecution case in particular. He's not explicitly part of the prosecution, but it would be surprising if he didn't know about it, considering they changed the prosecution case. So there are certainly questions about his independence and definitely his reliability, but that just doesn't seem to matter in this court case. Hi Chris mate, so interesting as ever. I was wondering, randomly as I do, would you like to believe that as there is so much coverage on Lucy's innocence now, that maybe her prison staff, guards, etc. would be treating her any differently now in a positive way to help her and support her now? I do hope so, but don't hold out much confidence. So it's difficult to predict this. It does seem that we've heard this prison... Apparently, the tabloid, is it the Daily Mirror, has some contact with a prison guard or prison officer or something, and he seems to have a very cynical and bitter view, essentially, quite sour perspective. I'm sure he's not representative of the prison staff as a whole, and one would hope that the prison staff understand the situation as people in the prison seemingly do, and that they're taking this into consideration to some extent. With that being said, they should treat Lucy professionally and appropriately in a professional way at all times, regardless of what they think about her. I don't know what happens in prisons. I've not been in a prison. I'm certainly not an expert on what goes on in prisons. One would hope that prison guards treat everyone with dignity, respect, and professionalism at all times. I'm sure that's not the case, but I hope that Lucy's being treated well. And certainly there will, as I've mentioned previously, there will be an enormous amount of security surrounding her. So she's actually quite safe in that sense. Shows the complexity and yet, the simplicity of Lucy's case, that it throws up so many questions. One question raised here also occurred to me. If Jayaram had so many suspicions from earlier that Lucy was harming babies, why didn't he or others in the team keep Lucy under close surveillance? So something you may not know is that this was suggested. It was suggested, well, why don't we just have someone looking after Lucy, as you suggest, keeping her under close surveillance? And this was rejected by the paediatric team. They wouldn't even consider it. They just wanted her taken off the unit. Now, I'm not going to speculate as to what were the reasons for that, but you may wish to consider why they weren't willing to engage in this measure that would seem to be completely natural to me. But that's an absolute fact, by the way. We've got the documents. That's not contentious in any way. Gutted, I missed submitting a question for your recent viewers' question video, Chris. I have often wondered if Paul Hughes actually believes Lucy Letby is guilty. I feel he surely can't have risen to the rank he is and be oblivious to the fact he got it so catastrophically wrong. Do you think he believes she's guilty? So I certainly initially very obviously did. At this point in time, if he has a grain of intelligence, he must be questioning it to some extent. However, we can all be guilty. I've discussed recently in videos with Susie Holt this idea of having self-serving beliefs. So we're all vulnerable to having self-serving beliefs, and when it's as serious as this, then Paul Hughes will do anything he possibly can, I've no doubt, to convince himself that it was a valid police investigation. In fact, it was a great police investigation, and Lucy Letby is definitely guilty, and these naysayers are crazy or biased or whatever it might be. So I'm sure that he's still trying to convince himself that Lucy Letby is guilty, whether in his heart, whether he categorically believes Lucy to be guilty and think there's no other possibility, I couldn't really say. But if he has any, as you say, intelligence, a grain of intelligence, then he should know that there are serious doubts about this verdict. As you say, he would need to be oblivious not to be aware of that, but it will be very difficult for him to admit to himself that he and Cheshire Police got this, as you describe it, catastrophically wrong, even though we know that they did. So I'm sure in his world, he's still trying to convince himself that he's right. If there is a retrial appeal, I can imagine the prosecution are going to rely on the phrase, Lucy Letby, the convicted serial killer. Can they use that line if they are there to retry the convictions? No, they can't, because she won't be convicted anymore. Essentially, the convictions will be overturned, and a retrial would be to try her again. So if she's sitting there in the witness box in a retrial, there is a presumption of innocence, and if there's a presumption of innocence, they can't say you're a convicted serial killer. I mean, they could say that if it was different convictions from a different court case, but effectively they're wiped out, so they can't say that. Absolutely not. Thank you, Chris. Great listening to this. Just one question. If no collusion, and I'm not suggesting there was, why the need to fabricate evidence such as seen by Ravi? Well, I don't know what Dr. Jayaram was thinking, and I don't know why he has done what he has chosen to do. It's impossible for me to say. Let me provide an alternative interpretation that is incredibly generous towards the consultants. So Dr. Jayaram could believe, and he could legitimately believe this, that when firstly, he may have tried to give accurate testimony in court. Now, it doesn't look like that. It looks like there's serious problems, but it could be a memory issue. Who knows what? It's very difficult for me to comment on this because I don't know what the hell he was thinking. But for example, the interest of the police email, a barrister could argue, if a barrister was asked to argue in favour of Jayaram, they could argue that while that language may appear to be inappropriate, it was coming from a good place. Like, they wanted to pique the interest of the police because they genuinely believed there was a murder and they were desperate for the police to look at the case. And if that required them to do things that were perhaps slightly underhand, that wasn't done out of deceit, it was done out of genuine concern. Now, that would be an incredibly generous interpretation, but we can't say definitively that evidence was fabricated. I know that it looks that way, but it can just be mistakes, it can be errors, and it can be the scenario that I've just suggested, albeit, as I say, that does seem quite fanciful. So that kind of gives an answer to your question. Obviously, I think that there are very serious question marks about what Dr. Jayaram has said in court, given that there is this existence of this email. That's very clear. Whether that means he fabricated the evidence or whether, who knows? It's simply impossible for me to say why he sat in a courtroom and said what he said. I'm not willing to speculate on that, and I can't know. So we'll just have to find out, if we ever do find out. It may be something that comes out in time. But it's a very difficult question to answer and address. Do you think Lucy Letby should have recognised the deteriorating signs of the babies, or was this the doctor's responsibility? So that's a very good question. The first thing is that Lucy did recognise numerous signs of deterioration, both at the time on the unit, which she expressed this to colleagues, and also in police interviews, and also during the court case. So it's important to remember that she did do this, firstly. Secondly, yes, Lucy definitely should have some responsibility to notice signs of deterioration. That's part of her role as a nurse, and it's an important part of her role. So it's definitely not solely the doctor's responsibility. I'm speaking for nurses here as a very unqualified person, but I think it would be reasonable to say that the nurses are very much the eyes and ears of the doctors and of the unit. So they are there to recognise these signs, because they have to call the doctors, of course. So it is incumbent upon Lucy to a certain extent, but also it's important to emphasise that she doesn't have the level of medical training and knowledge of the doctors. And once the doctors have been called, it is their responsibility to ultimately recognise the deteriorating signs at that point. And there are registrars there that also have to play a role in this. So Lucy doesn't have the ultimate responsibility, but she plays an important role. But in my estimation, she played that role quite well, because she did recognise the deteriorating signs. And not only did she recognise them, many of the assertions that she made, both in police interviews and in court, and indeed in text messages and comments to friends, were correct. She knew there were problems, and she recognised some of the serious problems, and she was right about the sewage, and she was right about the sepsis, and she was right about some of her assertions about these infants. What you can't expect her to do, as the police did and then the court did, the prosecution did in particular, was to give a universal explanation for absolutely everything that occurred on the unit. No one person can do that. Not even one doctor, not even the world's greatest neonatologist, not even if Nina Modi went in there would she be able to do it. So it's not her responsibility in that regard, but she should make a contribution towards patient care on the unit, and part of that is recognising problems, absolutely. Hey there, can I ask if anyone else is wondering why there was a maternity review, and that it could be positioned to allow the hospital involved in this to become part of a wider admittance of unacceptable care? Once that gets positioned correctly, then the political fallout from this will be less, and Lucy could have a chance of walking free. So it's an interesting point. Unfortunately, given the severity of Lucy's crimes, there isn't going to be such an easy outcome, I feel. But I do think the maternity review and the circumstances revolve. Clearly, there is the word crisis is bandied around far too much. Everything is a crisis. The cost of living crisis, etc. I mean, the cost of living crisis is not a crisis. It's due to systemic reasons, and it's not. The crisis implies that it will blow over after a certain period of time. I don't think it will. So the word crisis is overused, but in terms of the maternity crisis, it is very accurately used because there is a massive crisis in maternity, quite obviously. Now that gives crucial context to what occurred at the Countess of Chester, and it is very significant. But when your crimes are as serious as those that Lucy's been convicted of, unfortunately, even something of that significance isn't going to be a silver bullet or even necessarily make it easier for Lucy to walk free. It's the kind of thing that will be brought up contextually in the months and years to come, and as part of the political fallout that you mention. But I don't think it's necessarily going to help Lucy at this point in time. On the matter of the third speaker's justifiable concern that the police and criminal justice system are ill-equipped to investigate incidents in healthcare, don't the coroner's offices and inquest process provide the necessary mechanisms for investigations in healthcare settings? So that's absolutely true. Obviously, the coroner's been involved in this case. There's been pathologist involvement. But for whatever reason, the police have allowed Dr. Evans to walk into the office, walk into their police station, and completely overturn all of the coroner verdicts, all the pathology, everything that was a much stronger process than anything that Dr. Evans could or ever do. There's nothing else you can possibly say about that. It shouldn't have happened. Ideally, in an ideal world, I wouldn't even be sitting here saying this, because the coroner's verdicts wouldn't have been overturned. But the fact is, the police have the power to do that. They've allowed Dr. Evans to effectively pull the wool over their eyes, and now the coroner's verdicts are irrelevant. And we've got to overturn the court's verdicts, which become far more powerful than the verdicts of the coroner. It's absolutely true that the police and criminal justice system are ill-equipped to investigate incidents in healthcare, but unfortunately legally they're able to do it, and they've done it in this case, and now we're dealing with the fallout and consequences from that. I'm coming to the conclusion that lawyers and judges really don't have any understanding of statistical data. The manipulation of Arthur's data until it appeared to support the prosecution was blatantly obvious from the beginning. Why on earth did the defence allow them to get away with it? So I think it's clear that lawyers and judges don't have any understanding of statistical data and that they don't have understanding of a lot of things. They're more concerned with policy, procedure and the law. In terms of why the defence allowed them to get away with the manipulation of Arthur's data, there were some good things done by the defence and some bad things done. But I find it strange that you're allowed to have a paper, a so-called study, in a court case. It's not been peer-reviewed, it's not been published. It's all right if there's empirical data that already exists, and you cite that empirical data in the court case. Why has something been commissioned, but then it doesn't go through any of the normal academic process? That, to me, is at best, very strange. I think ultimately the defence didn't allow them to get away with it. They just couldn't land enough blows, partly perhaps due to Meyer's strategy and partly due to the disadvantages that the defence inherently has in court cases, and particularly in this court case. So it's an unfortunate situation. I think it's fair to criticise some of the things that Ben Myers did. I don't know whether he could have put up a better defence on this issue. We may examine that one day, but he was faced with a very difficult task, is all I can say. But Arthur's study should never be in the court case, in my opinion. It's yet another thing that just shouldn't be in there. Great Ormond Street Hospital has its own toxicity. I have seen up close and personal consultants knifing each other in the back. Is it just the NHS, or is it the case in all professions and walks of life? So this is a very interesting question. Obviously, any answer that I give to the question regarding whether it's in all walks of life is based on personal experience and personal perspective. I can't say definitively that it's the case in all professions, but I think broadly speaking, it is very common in all walks of life. I know from my personal experience that when I've worked in normal workplaces, there's always problems with backstabbing and politics and gossip and personality clashes and cliques and all of these things. In the last job that I worked in, I'll give you a little anecdote. So the girl who used to be our cleaner for that office, she developed a crush on me. And I think the sole reason, well, I know the sole reason for that. I'd love to say it's because I'm devastatingly handsome and incredibly charming, but realistically, the reason for that was I was the only person who was nice to her. And I wasn't excessively nice to her, I was just respectful and polite. And not everyone was horrible to her, but she wasn't. I thought people treated her really badly. I'm not going to go into all the details, there's no point, but you often get that thing of people at the bottom being hammered, and it surprises me how prone people are to I don't know, elevate themselves above others somehow and think, oh, well, I'm a member of staff and this is just the cleaner. Whereas I just treat everyone the same way, and I hate that attitude of, well, it's sort of vaguely elitist, I suppose, but I just treat everyone with the same respect and treat everyone the same way. And I'm not excessively respectful to people of high status, and I'm certainly not rude to people of what would be deemed low status. I just treat everyone the same. A lot of people don't have the ability to do that. I don't know if that's due to inherent human qualities, inherent human genetics or something, or if it's due to societal conditioning, or if it's a combination of both. I don't really know, but I think it's very common to have backstabbing. However, I think in the NHS, firstly, I've heard reports from many healthcare professionals now which suggest that the culture is particularly toxic. And these reports have been too numerous and too consistent for me to dismiss them. So I think it's very, very clearly true. And then if you think about the particular qualities of the NHS, then there are reasons why this would be the case. The first thing is it's hierarchical, it's a very hierarchical organisation. So that tends to result in this sort of behaviour because it amplifies the trends that I've just described that occur in normal professions or, in more broadly. The second thing is that there's a lot at stake. It's life and death circumstances, which is quite rare in a workplace, and that can, you would hope that would make people pull together, and I'm sure it does sometimes. But it can also result in people acting in self-preservation because they know the consequences of being wrong are much greater. And I think that is running right through this case, is that the paediatricians know we're ultimately responsible. This is a really bad series of results. And whether consciously or subconsciously, it's easy for a kind of self-serving mentality to develop where they think we're going to be ultimately held responsible for this. We need to come to any other conclusion other than that. And that can be a very self-serving motivation for them. And then I suppose a third thing is the kind of godlike status that is afforded to the consultant. So that can result, as we've seen in the case of Dr. Evans, in extreme arrogance at times. And the more you go down the path of egotism and go down the path of conceit, the more and more you become detached from normal human emotions and the way that you should behave, and empathy and all of these things that would result in good conduct. The consultants really are put on a pedestal. And you do have to, I think particularly for men, I mean, I've discussed this previously, men are particularly vulnerable to egotism. I'm not saying women are not vulnerable to it, they are, but men are particularly vulnerable to it. So if you're in a situation where you're getting a lot of praise and a lot of recognition, then you've really got to quite actively practice humility. Otherwise you can become very vulnerable to becoming an egotistical, egocentric, quite arrogant, self-regarding person. I suppose that I've seen that, even when I was a writer, I'd probably seen a little bit of this because, it's a slightly unusual profession. People say things to you that are complimentary, I suppose. And of course, it's escalated a lot since I've had YouTube. So I've always been very aware of this. So I quite actively practice gratitude and humility because I think it's very important. I don't want to change as a person. I want to be the same person I was when I began. But if you don't do that, then your ego can run away with you. And then, of course, the other thing as well is that for a consultant, they're dealing with very complex medical information that most people simply do not understand. So one of the comments Dr. Evans made was, everyone used to defer to my opinion. So you get used to that outlook. And you can, if you're not careful, you can more and more and more believe it's because you're some sort of incredible superhuman being. And that obviously is not a very... if everyone's deferring to you all the time, if everyone's praising you all the time, if you're talking about things that no one else can understand, you think, oh my God, I can understand all these complex things about pediatrics that no one else can, it's very, very easy for your ego to run away with you. And then, of course, in this particular situation with the consultants, a fourth factor is that they're a group with common self-serving interests. So they can egg it. Dr. Breary, in my view, is the ringleader of this group and has inculcated them into his perspective. But they all kind of egg each other on in a way because they all have a shared view. You see a little bit of dissent from Gibbs, a little bit of dissent from Salady, but ultimately they can join together, join forces, as it were, and then they form a kind of echo chamber, and then they only see one perspective and they reinforce it. Then it builds and builds, and that's what I ultimately think happened. As I've said, I don't think Lucy was deliberately targeted because even though lots of people believe that, it would be an enormous risk to do that. Also, given that they're already looking for commonality in June and definitely in July 2015, they had no idea what was going to happen on the unit at that point. They didn't know there were going to be as many deaths as there were. So I think for her to be targeted at that time was untenable. However, it's possible. I fully accept that lots of people believe this. I don't know for sure. But the point is that the culture of there being a paediatric team, them all being consultants, them having a level of knowledge that no one else does, the personality aspects that I already described, it can create this culture in which backstabbing becomes commonplace. If all of the elements are there to create a toxic culture, and that's why so many people are reporting this to me. However, I do think this is not uncommon in all walks of life, and you'd probably see similar things in other hierarchical institutions. I'm sure it would be the same in politics, as an example. I'm sure that, well, we know there's all manner of backstabbing that goes on, but I think other professions where there is a hierarchy and other professions where there's a lot at stake, you'll typically see similar behaviour. Some good stuff in this. Why did the judge not question Professor Arthur's research? It was clearly twisted and biased towards the Crown Prosecution Service. So with regard to this, the main thing that I would say is that I find it strange, to say the least, that there is a study in a court case that's been commissioned solely for that court case. It hasn't been peer reviewed, it hasn't been published, it hasn't essentially gone through the normal academic process that you would associate with academic work. So why is this occurred? It would be normal to cite existing academic work. If there's existing work out there, then you could use that in the courtroom. If Professor Arthur's had done some research and it had been through a normal academic process, then it would be more legitimate. But I can't understand how something is commissioned but it doesn't go through the normal academic procedure. With that being said, we know, as mentioned previously, that Professor Arthur's research does not support the prosecution, quite the opposite. I think in answer to the question of why the judge did not question his research, it's very likely the judge doesn't understand the case. I am certainly of the opinion that the judge does not understand the case, cannot understand the case, and it's very hard to put yourself in the position of the judge, but there's a degree of complacency, I think, but also they've just been in the criminal justice system for so long. They just think, well, this is what we do. We put a load of evidence in a court case, the two sides argue it out, then the jury decides, then the person goes down. They have to believe in that process, even though there's these figures that suggest there could be between 2,000 and 10,000 innocent people in prison. And that's not surprising when you assess this case, when you examine this case, because it's clear that the police and the Crown Prosecution Service are willing to put cases in court that don't have definitive evidence. So if there isn't definitive evidence and there isn't very strong proof, it's obvious that there can be a miscarriage of justice at any time, because you're just relying on the discernment of the jury to assess what can often be very tenuous or at best circumstantial evidence. It's obvious the jury can get it wrong, but the judge can be very complacent about that because the judge goes through this process all the time. So he may just simply not recognise the significance of, as you say, this research that's twisted and biased towards the Crown Prosecution Service. He might just think, well, it's a scientific report, this guy's a scientist, it's perfectly okay. Obviously, I'm of the opinion that the judge didn't do much for Lucy in this court case, but I think a lot of it is just simply the judge does not understand the case, does not recognise the problems with the case, is complacent because they've been in the criminal justice system for a long time, and just cannot preside over the case in the way that was necessary. There's no excuse for not throwing Evans out the court case, but I think other things, Judge Goss just simply did not understand them. So there isn't too much I can add to the second point. It is very clear that Lucy was a scapegoat, and the court proceedings indeed did nothing to stop confirmation bias. With regard to the third question, why are the nurses and healthcare professional unions so quiet? It's simply because institutions are always resistant to controversy, and they always know politically it'll be easier for us to do this. They have a very astute, almost inbuilt tendency to do the least controversial thing possible in all circumstances. You or I might look about it and think morally and ethically they're the unions and they must represent Lucy. That's what they're supposed to do, and it's very disappointing that they haven't. But I'm not surprised, because that's the way institutions work. Institutions act in self-preservation. We're coming back to the topic of self-preservation, self-serving positions, as that we will come back to again in the future, no doubt. The healthcare and nurses union just thinks, don't get involved, it's controversial for us. If we defend Lucy and she turns out to be guilty, we're on a hiding to nothing, just stay out of it, and if she's exonerated, then we can help her then. I know that may seem very cynical, but the world is a cynical place, and that's the way that's the way it is. It's very disappointing, but we see a lot of these organisations, they either don't do anything or they carry no weight, or both. So, for example, Dr. Martin Pittman, his career as an obstetrician sadly is over by his own admission, and he's fully backed by the British Medical Association, but that didn't help him at all. Lucy's union could have helped her, and again, that may not have helped her in the slightest. It probably wouldn't have helped her. Now, I think it's very disappointing, possibly even despicable, that nursing unions have done so little for her and have been so quiet, even in the current situation. But ultimately, as I say, they just act in a manner of self-preservation, and they just think, institutionally, if we stick our nose in, we gain nothing, and we could lose a lot. Whereas if we do nothing, we can say, oh, well, you couldn't expect us to defend a convicted murderer. We didn't know. And as soon as we realised that she wasn't guilty, we helped her as soon as we possibly could. And that's kind of seen as the low-risk strategy. That's just how these organisations and institutions work. In terms of why you should stay a member if they won't speak up for you, that's a very good question. In principle, I advocate unionisation, and it's probably better than having no unions, but in reality, they're just yet another blunt instrument that, in my view, very often achieve very little or absolutely nothing. With that being said, that's the end of this question and answer session, and it will be my final video for 2025. So it's been a year in which my life changed quite a bit because I became a YouTuber and obviously became quite prominent in this Lucy Letby campaign. Next year is going to be bigger still, and it's going to be a big year for Lucy. So I want to take this opportunity firstly to thank you for your support this year and reiterate that I really need your support next year. And to wish everyone a happy new year, and again just give a thought to Lucy over the New Year period, because she will be incarcerated. It'll be the 6th time she's seen in New Year in prison. It looks like there'll probably be a 7th time. It looks like there'll probably be an 8th time, and there could be a 9th and 10th time as well. And who knows what's going to happen ultimately. So do spare a thought for her, but enjoy the new year for yourselves. And I'll see you again in 2026.